All right, well, good morning, everybody. How's it been going so far? Yeah, yay! AI governance, regulation, oversight. I also would say yay to that. Okay, so I am Brandie Nonnecke. I'm the director of the CITRIS Policy Lab, which supports empirical research and translates that into impactful policy deliverables. I'm also on the faculty at the Goldman School of Public Policy and a faculty co-director at the Berkeley Center for Law and Technology. I'm also the host of a video and podcast series called Tech Hype, where we debunk misunderstandings around emerging technologies and the laws and policies that shape them. So please check it out at techhype.org. Today, I'm really excited for this panel. We're going to be diving into state and local AI governance strategies, and we have such esteemed speakers with great depth of experience and expertise. I am certain we are going to learn a lot today. So to kick us off, I'll give an overview of the panel and the topics that we're going to be discussing today. I'll then pass it to each of the panelists to give 5 minutes of introductory remarks, and then we'll discuss questions among us, and then we'll open it up for audience Q&A. Please do wait for the microphone that will be passed around just to ensure that everybody can hear, and then I also believe this is being recorded, and that way we capture your questions on the audio. So we all know that in California, Governor Gavin Newsom signed an executive order on generative AI, looking to identify ways the state could harness this transformative technology to make our government operations more efficient, effective, and equitable. Now, that has been in effect for some time, and many of the deliverables have been produced and were spearheaded in large part by Jonathan Porat, the Chief Technology Officer for the state of California. So one thing we really want to get into today is what's been working at the state and local level around AI governance. What can we learn from the experience in the state of California? I also helped to advise the state of Washington's implementation of their executive order on generative AI, which very much mirrors California's. And we face some of the same obstacles, but also some of the same opportunities to leverage that moment to make sure that we put in place responsible AI governance strategies that are fit for purpose, not only for generative AI, but all forms of machine learning now and in the future. And with that, I would like to pass it first to Jonathan Porat to give a few open remarks.
Yeah, thank you so much, Brandie, for organizing the panel. Thank you, everyone, for inviting me and taking some time to join us today. I'm always really fortunate to have a chance to come to Berkeley, especially because the last few times I've been speaking out in the Bay Area, I've been in San Francisco, where the reaction to AI governance is not always yay from everyone. So excited to hear some different perspectives from our panelists and some questions from you all. But I want to take a little bit of time just to walk through kind of what that approach has been to the executive order. And it really is great timing to speak about that because last year we were proud to have Governor Newsom issue one of the first executive orders on generative AI in the country. And just last week, we released our last policy officially implementing that executive order. And we'll talk a little bit more in a second about kind of our transition from executive order and think about the vision of Gen AI to some more specific governance and policy itself. But one thing that I'm especially proud and happy about is that we took a really intentional and deliberative approach to Gen AI. We're seeing with some approaches from the federal government now that there are definitely a perspective of we should have no regulation, we should not do anything to limit Gen AI, and there's definitely some governments that have taken a much more aggressive approach, saying we need to minimize the advancement of Gen AI as much as possible until we have a real handle on it. So at the state, we took kind of an approach that was more in the middle, and instead of starting with policy, we started with trying to figure out what are those benefits that we want to get out of generative AI at the state, and what are the risks that we want to mitigate or prevent. So we really wanted to figure out what are those outcomes that we care the most about, and I'll speak about that probably a little more later in the panel. But from there, we were able to reach out to our community, so experts like Brandie, academic experts like here at UC Berkeley, as well as some other schools you might know in the Bay Area that I won't name out of fear of getting booed out of the room, but also meeting with actual people from our communities, nonprofits, as well as tech industry experts as well, so that as we're establishing those benefits and those risks, as we're establishing those values that we care about, those are values that are coming from experts and coming from our community, not just unilaterally from the state. From there, we were able to build out some guidelines. So again, not policy yet, but at least putting those restrictions in place so folks at the state know, for example, that we never want to use AI to intentionally get rid of a state worker's job, or we want to conversely, use AI to make state workers' jobs better and easier and more effective. And from there, we started issuing actual policy around things like procurement, governance, training, all of that holistically. And a lot of that culminated in some learning by doing for us, in that we had 5 Gen AI high-value business proposition use cases that we actually tested internally at the state with the state's own hardware, with the state's own workers, to test out how would Gen AI actually work here for things like analyzing large data sets, for translation, for things like helping out folks who work in call centers. And I'll just end by saying one thing that really has stood out throughout this is that we've benefited from having a much more outcome-based approach. A lot of times when we, and I'm speaking very broadly, but when we as in government do governance, when we do policy, we like to focus on very prescriptive ways of looking at governance. So if you meet these requirements, then you're good to go, then you're secure. And I think for some longer standing technologies, you can do that because we have a better understanding of how those technologies work. There's more of a coalescence around best practices from industry. But for Gen AI, you're not always going to be able to do that. And a great example of that is when we started this journey, a year or so ago, we thought, well, to do Gen AI, you're going to have to do a lot of custom development. The only way you're going to be able to get Gen AI is to have all of this extreme computing power and a lot of development knowledge. And what we're seeing now is Gen AI is really part of everything that's going on at the state. So as we start to transition from just kind of this broader visionary approach to the actual policy, we're realizing that that comprehensiveness has been really critical, because Gen AI is not just in custom app development. It's also now a part of our productivity tools. It's a part of what our vendors are using. It's a part of agreements with other partners. And so we've really had to make sure that we're aligning with those overall values and not getting caught up in individual technologies or individual requirements. So looking forward to hearing those thoughts from other members on the panel and talking about a little bit more as well.
Great. Thank you, Jonathan, for that overview. I have many follow-up questions, but I will hold. Next is Jennifer Urban. She's the chair of the California Privacy Protection Agency Board and a clinical professor of law and director of the Samuelson Law, Technology, and Public Policy Clinic, and also a co-director at the Berkeley Center for Law and Technology.
Thank you very much. Brandie, are we using first names? Okay.
Yeah, I did too. I said John.
I walked in a little bit late. Okay. The first thing that I want to do actually is welcome Brandie Nonnecke, who is our newest member of the California Privacy Protection Agency Board, appointed by the Assembly 2 or 3 weeks ago.
Yes.
And I'm absolutely delighted for the board and the agency, and thus the people of California, to have the benefit of her expertise. I'm going to do the disclaimers for both of us.
Thank you. I'm still learning.
We must say that we speak only for ourselves, not for the agency or not for its board. And there is a particularly, there's sort of a particular addition to that right now. The agency is in the midst of working on a formal rulemaking process for automated decision-making technologies, cybersecurity assessments, risk assessments, and a number of other things. The formal comment period recently closed, and the board has not had an opportunity to discuss the comments or the rules, any staff recommendations for the rules in a properly noticed public meeting. So given that, we will, as we would always do, only discuss public decisions or public information. And in this case, we can't give our views on those things. So we'll have to be rather neutral until we have a properly noticed public meeting of the board, and then we can debate them all we want. So I want to touch on 2 themes. One is one that is, they both I think have been coming up quite a bit over the course of this wonderful conference discussion. One is the use of the term AI and what we mean by that, and it's sort of thrown around, and how we sort of think about regulating, exercising governance in an area where there's clearly a change and it's not always very well defined. And the second is whether to take a more targeted approach, following on use cases and some specific governance based on that, for example, or a more generalized approach. And I think that is congruent with sort of some of the points Jonathan was making as well. So we'll talk about that later. So I'll just say a very few words about the CPPA's work to set the stage, and then California. And then we can talk about things in more detail over the course of the discussion. So the California Consumer Privacy Act is what the CPPA, our agency, has jurisdiction over. It is technology neutral. It is centered on personal information of consumers, and consumers are simply natural persons who are resident in California. So their activity in the marketplace is not relevant. And protecting the fundamental privacy rights of those Californians with attention to the impact on businesses and innovation. That is the lodestone, and that is the center of the mission of the agency and of the law, and it creates a series of consumer rights and obligations on businesses that are centered on that mission and on personal information. So, with regards to the conference today, the agency is tasked by our implementing statute required to develop regulations on the access and opt-out rights with respect to businesses' processing of personal information, so the lodestone, personal information, in their use of automated decision-making technology, including profiling. And the access requests have to include meaningful information about the logic involved in the decision-making processes, as well as a description of the likely outcome of the process with respect to the consumer. And then ADMT, when we talk about AI, it refers to any technology that processes personal information, so that's the lodestone, and uses computation to execute a decision, something else we've heard several times over the course of the conference as a theme. Executing a decision, replace human decision-making, or substantially facilitating human decision-making. It's only certain decisions, which we can talk about later. So ADMT, or automated decision-making technology, doesn't have to be AI, and not all AI uses would be covered under the draft regulations. I'm thinking of what Sorrell said earlier about, linear regression is AI in my class. It's really focused on that personal information, the rights, and what it's actually doing in the world. In addition, the agency must issue regulations requiring businesses whose processing of personal information presents a significant risk, another theme, risk-based, to consumers' privacy or security on cybersecurity audits and risk assessments. And so the theme is that this can come under the relevant activities and the statute's sort of mission and purpose, and the proposed regulations are centered on those rights and obligations. Later, also, maybe we can talk about CPPA's own deployment of technology in the delete request and opt-out platform, which is tied directly to the government deployment of technology and how the CPPA is thinking about that, although we haven't met on it yet, so I have only the staff notes. And then for California, generally, just a small note, there has been a coordinated effort, as Jonathan described, for government procurement and use. And there's also been a lot of activity in the legislature, dozens and dozens of bills, and a lot of those, or most of those, have generally been targeted to a particular problem or to a particular use case. And so to the second sort of theme, whether we think about targeted governance or we think about more sort of generalized governance, California has been focusing mostly on that second or that first option, although as Brandie described yesterday, there are some more generalized ones, like for the foundation model, SB 1047, that was vetoed. So I really look forward to the conversation.
Great. Thank you so much, Jennifer. And next is Paul Ohm, Professor of Law at Georgetown Law.
Hi, everyone. I explained to my students that when you do interdisciplinary work, your first job is to look around the room and see what is less represented, and that's how you introduce yourself. So I'm here on behalf of 49 other states of the United States. I'm the only
Now, hang on. Our we had a Colorado person.
What's that?
They couldn't make it.
Yeah.
Yeah.
So I am the only non-current government official, although I am a recidivist government official, and of most direct import. And I hope to bring in a lot of these experiences in this panel. I'm really honored to be with my co-panelists. I was recruited by Attorney General Phil Weiser of the state of Colorado when his state passed the Colorado Privacy Act, not the more famous in this room AI Act. And part of what was in there, and I think it's actually a significant part, like California, there are only 2 laws in this country of these state privacy laws that give rulemaking authority to the Attorney General or the CPPA. So Phil called me and said, I want you to work with 2 of my attorneys to write the privacy rules. And I said, well, that feels like cheating because I'm a law professor and I'm trying to influence what the rules say, but usually I don't get to be in the room and write them down. And so I know you all have read the rules and you love them. The good parts are from me. But I'm going to give a bigger disclaimer, which is I hope if I do my job right on this panel, Phil Weiser will disavow that I ever worked with him. And I certainly left the office before the AI Act was even a gleam in a Colorado legislator's eye, although I've been attentive to it. Margot Kaminsky, is Margot here? She's much more directly involved in the Colorado AI Act, so when I get that wrong, she'll call me out. So I want to do 2 quick provocations in the minute and a half I have left. And I want to think more kind of perhaps as a law professor or as a litigator about the challenges that no doubt will come very soon to some of the AI laws that are being passed around the country. And I want to call out one is a kind of piece of rhetoric that often gets thrown around when you're critiquing a state AI law. And then 2, I want to actually have an argument about something that will matter in the courts. The piece of rhetoric is patchwork, right? Mm-hmm. There's no bigger insult than to refer to the patchwork of state laws. And yet if you image search patchwork, you are overcome by beautiful images of quilts that reflect the coordination of many hands working together, right, in a common goal to create something beautiful and harmonious. And so in the pages of the Berkeley Technology Law Journal, in an article having nothing to do with the symposium, I'm about to publish something that ends with an ode to the patchwork and how when a patchwork is done right, it actually kind of the whole is better than the sum of the parts. And I actually think that describes privacy law as it's unfolded in this country and perhaps can also inform what's about to happen with AI law. Let me say one more sentence on that and then I'll leave you during Q&A or if I get something thrown at me by the panel to say a little bit more. If you look at the 19 privacy laws that have been enacted, they're not that inconsistent with one another. They're deeply interoperable with one another. And instead what you see is kind of a lot of coordination between people in different states. You also see an interesting evolution over time, right? The laws get, this is a very long sentence, by the way. The laws get stronger and better and more interesting, and you have a little fork in the road where this one's a little more industry authored and this one's a little more civil society inflected. But it's actually kind of a harmonious regulatory scheme as opposed to the 19 different things that are completely inconsistent. Okay, that's patchwork. Number 2, I am now embarking, and this is way too early to be talking about this research, so don't ask me what my proof is. I don't have it yet, but I'm embarking on a major project with someone who dabbles in history, and we both dislike economists, but we're pretending to think economics. And our argument is, and I'm gonna probably just state it and support it a little and let you push back in Q&A. In the history of industrial regulation, there has never been a technology that is as cheap and easy to change as the current wave of artificial intelligent kind of inflected software. That if you compare it to like railroads and telephone networks and all of the other things that private industry has created over the last century and a half, there's something funny happening at this moment where kind of 3 engineers and a bunch of, what is it, Celsius is the energy drink of choice, and a week can take a product that does X and change it so it does not X. Can take a product that does one thing that creates a harm and change it into a product that no longer does that harm. And if we're right, this will of course be important in First Amendment challenges, Dormant Commerce Clause challenges. It doesn't mean that these laws are always rational, wise, and should be, the law of the land. it just means it doesn't cost the companies almost anything to comply. And I think that even goes to things like impact assessments, but I know that'll just like burn the house down, and so I'll let you push back on me. Although I did like the way Jonathan started. Like, maybe I'm okay because I'm not in San Francisco seeing these things. I hope. I'm gonna hold you to that. All right, thank you, appreciate it.
Great. Thank you so much, Paul. I'll push back a little bit on that because I think also the internet and websites, platforms
Yeah.
is the same thing. We had the .com boom. I definitely think we're going to have a bubble burst
Sure.
around the AI space coming up very soon.
Yeah.
So I have an overarching question for the three of you. We've been discussing the role of states like California, Washington issuing executive orders. California has our data protection law, also Colorado. How are you seeing these efforts really sew together that AI quilt of governance strategies across the United States?
Do you want me to start?
Yeah, go ahead.
I feel like you brought this up. I have patchwork in my notes too.
Oh, perfect.
With the same sort of flavor on it, that people, worry about a patchwork. They worry, understandably, about incompatible compliance obligations or overlapping in unuseful ways, compliance obligations that overlap in unuseful ways. So in terms of how I think the patchwork is developing positively, there are, of course, differences in detail, but there are a lot of really similar themes and central approaches. So, for example, I described what the California law focuses on, the consumer privacy law focuses on, and Colorado focuses on, it's broader sweeping in terms of that it's not just focused on personal information, but it focuses on predictive AI systems that are capable of making decisions. And the CCPA, for our purposes today, focuses on automated decision making. The GDPR also does, and we heard in the federal panel themes that are similar, and they both regulate where there are some kind of significant decisions or significant effects, and those significant effects can be seen as congruent often with the high-risk systems, is another way to think about it. The Colorado law talks about both of those concepts. The California law talks about risk when it comes to risk assessments and cybersecurity. So across the sectors, the approaches really converge on a lot of very similar things. So that's one thing. The devil, of course, can be in the details because you can be trying to get to the same goal, and of course you could have incompatible compliance requirements, et cetera. But I know from California's perspective, that we actually have in our statute, the agency is both responsible for and empowered to collaborate with other jurisdictions, other agencies and policymakers and regulators in California, in the United States, and indeed internationally. And that has been a very active focus of the agency, even in its young life. So we have, I know that staff have worked with the Colorado folks, and they've worked with NAG, the Attorneys General, the National Association of Attorneys General. We have an MOU with the CNIL in France. We're a part of the Global Privacy Assembly of Regulators across the world, and the Asia Pacific version of that, and others. There's a really active attempt and work to, while we will have to have localized solutions that are appropriate for our populations, to harmonize those things.
Jonathan, Paul.
Yeah, I mean, let me jump in. It's useful to look at these analogs. I mean, one funny thing is when you look at kind of comprehensive AI law, whatever that means, there aren't that many. And so let's talk about one other precursor we haven't put on the table yet, which is data breach notification law. So I'm old enough to remember when, California led the way on that. Now we have 50 data breach notification laws, and when I was at the Federal Trade Commission 10 years ago now, there were people in the audience saying, this is a patchwork, this is impossible, there's all these little tiny inconsistencies between them. And what happened is the law firms quickly adopted a business model where it's a one-stop shop. You have a data breach, you go to a law firm, they know exactly how to comply, they know which states are a little bit different, but for the most part, there's a ton of interoperability baked into it. When I was in Colorado, we actually, in some of the rules we wrote, put in provisions that said, hey, by the way, if you're complying substantially with these rules because you're complying completely with the rules of another state, that's fine for us. And so there are ways to bake in explicit interoperability, not only in your rules, but in your statutes. And I remember, I think it was Commissioner Julie Brill at the time, was at a public forum and someone in the data breach context said, this is impossible, this is gonna bankrupt our company. And she's like, what are you talking about? I mean, some second-year associate has to spend a few more hours at a word processor, deal with it, and guess what? There's no federal data breach notification law outside of the little HIPAA amendment because industry has learned to deal with it, because the sky didn't fall. And at the same time, we sort of have a nationalized data breach rule, which is sort of maybe where we end up with AI, especially if Congress continues to be Congress and does nothing. Right?
So I also have kind of more of a technical perspective on this, but at a high level, I'll take everybody back to like elementary school social studies. And I think a big part of this is it's really difficult. And as someone who worked in the Office of Information Regulatory Affairs at OMB, it's really tough for the federal government to issue regulations like this because it has to be one size fits all. So there's an advantage where, like you're seeing, states can coalesce around common themes, but also they have that flexibility to lean more into values. Like for us in California, it's equity and inclusion that may not be the value everywhere else and may be difficult to nationalize across. Similarly, the federal government is thinking about things like military concerns, international geopolitics, that is not always going to be of the utmost importance to every single state, even though some states are a little more or less involved in that. I think the thing that I want to focus on when it comes to this is kind of the tech stuff on the back end. And I think the thing that's been the most kind of intriguing to me about where a lot of the industry has gone is the industry is kind of throwing their hands up and saying, we ran out of energy and we ran out of data to keep pushing these models. And one thing that's been kind of unexpected on our side is we do run an open source and an open data platform. We're really proud of it. We continue to reinvest in those kind of options to give data available to researchers and startups and just regular Californians or whoever's interested. But the things that are the most utilized data sets on those sites are things like county lines, zip codes, definitions of like boundaries for like rivers or lakes. And what we're seeing is there's this huge importance to have authoritative data out there. That's also what makes it kind of heartbreaking to see the recent path the federal government is on in terms of removing data. Because to Paul's earlier point, one thing that has been really exciting about the development of AI tools is there is this capacity for startups to have as big, if not more innovative solutions than some of the well-established tech companies. And we've seen that as we've met with folks, especially around the Bay Area and Silicon Valley, even other parts of California. And we've actually reached out to those companies and learned that, for example, there are companies working on smart traffic lights for Oakland and the Bay Area around here. It's really important for them to have good data on car accidents, on traffic patterns, things like that. So we've actually gone back and made more connections with California Highway Patrol, with the Department of Transportation, so that we can get some of this authoritative data out there. Similarly, there's a real concern around access to compute power. It can be really tough to get the GPUs you need to be able to do this kind of research, especially if you're just a student or you're a startup. And so, as you've seen in the governor's budget, we proposed a solution to that as well, where we hope to work with many of the people who are in this room to try to democratize that a little bit better too. So I'm hoping that in addition to allowing these kind of general themes to come out, that will be a signal to industry. We care about things like high-risk automated decision systems. We don't want AI making key decisions that humans should be making that may affect other humans. It also gives us the flexibility to really lean into those areas that both we find important and are going to be really critical for developing more localized solutions that's going to help that state. So I hope we can come together, especially if the federal government sees itself as kind of shrinking away from taking a more open role on things like data and infrastructure and security, and stand up that quilt patchwork, whatever the positive connotation of that is, so that we can give students and researchers and new businesses what they need to be able to really innovate and give us better solutions.
Great, thank you so much. One thing I'm hearing among the three of you are tropes and hype. We often hear the trope from industry that regulation stifles innovation. And I don't know if we've seen such a hype technology in quite some time, especially around AI. When the executive order came out, my knee-jerk reaction was, why in the world are we just focusing on generative AI when we currently use many forms of machine learning in high-risk decision-making settings? But sure, let's all pay attention to the shiny new toy. My question is, how do we balance industry pushing these tropes on state departments, agencies, and lawmakers? And also, how do we cut through the hype to make sure that our efforts are going to be effective, fit for purpose, and center the public interest? Who wants to go first?
I mean, I'm happy to. Listen, it's at this stage in the panel, I'm thinking we're not going to disagree on much up here. So maybe I'll push a little bit in one direction just to try and spark a little disagreement. I agree, like the rhetoric and the politics around fighting regulation is almost like a separate problem from, is this good regulation, right? And so I've been really bothered by kind of, especially in California, the aggressive rise of net choice. I don't even know who net choice is, but I've got this picture in my head where they're just like really unpleasant people and you wouldn't want to talk to them at a cocktail party. But the kind of scorched earth warfare they're lodging against any law that gets proposed, marshaling out, frankly, arguments that I don't think their members would ever marshal out. They wouldn't want to be associated with it, but there's something about the trade association structure. And they use tropes and rhetoric constantly as a sword. And so I don't know, like we should call out people who do this, and we should make it a little socially unacceptable to be taking a job at Net Choice. I'm sorry to personalize it so much, and I can see my co-panelists are getting nervous with where I'm going with this. I mean, I also very much like in the spirit of the disaster we're living through, innovation's a word that my little group at Georgetown's been thinking a lot about trying to reclaim. Another one is efficiency, right? And so if any of you have heard me talk in the last 3 years, you've probably heard me sing the praises of friction. But one thing it took me about a year into that work to realize is everyone uses friction. And people in pursuit of efficiency are often deciding where to place the friction, right? The dark pattern that makes it a little bit harder for your user to opt out allows you to achieve some efficient goal. And so in a funny way, I think we've got it wrong. I think we shouldn't have this, and I know everyone in the room already has had this thought, we shouldn't have this kind of unbridled, unthinking pursuit of efficiency. What we should try and do is in every given moment figure out where the efficiency goes and where the friction goes, who decides, and how to make sure that both of them are always part of the conversation. All right, so I guess I introduced a trope to kind of fight against tropes.
We got
So.
Yeah, we got some hype and additional tropes. So
Sure.
This is good. Jennifer, did you have something to add?
I do. Do you want to go first?
Sure, I can jump in for a second. And I think this gets back to what you were talking about, Jennifer, with balancing comprehensive versus more targeted regulation and policy. And what I've tended to see, especially when some of these new developments pop up in the news, like there was an open source AI tool that was developed outside of the United States that got people very excited. There tends to be a rush and a temptation to say, we need to regulate that exact tool instead of thinking about, and that's why I'm proud that we have Jennifer, we have Brandie working at CPPA and thinking comprehensively, what are those data and privacy protections we need? Because honestly, everyone is concerned about that tool, but if you don't have the right data labeling, the right data governance, Microsoft Outlook can be equally as dangerous as that tool can be in terms of people not knowing what they're doing and sharing private or personal information. So for us, it kind of goes back to what we were talking about, which is thinking through what are those high-level things that are kind of non-negotiable or really critical as part of our work. And one thing, I think people will appreciate a more targeted example, but one thing that we released recently was we changed our terms and conditions around the way we did procurement for technology. Originally, we had a bunch of different terms and conditions for if you're trying to procure cloud at the state or AI or whatever it is. And what we've started doing is combining those so that we just have high-level rules around you can't sell state residence data, period. It doesn't matter what technology you're selling. That's not something we're interested in. You can't use it without our consent or without our interest in training an LLM or using it to further your financial interest without us knowing that and being a co-partner and having the right controls in place. So we're really thinking about how can we make sure that we don't just kind of become, like dog chasing squirrel car and jumping on Gen AI or jumping on particular tools, and really trying to be smart about it and thinking, well, what are the actual outcomes we're trying to promote? Because a lot of times there are unique risks with Gen AI. There may be unique risks associated with a particular tool, but a lot of times people are hoping that by regulating this one item that is very salient, that just magically will take care of all of the other concerns around data privacy and protection.
So in my role at the CPPA, on the CPPA board, we are charged with attention to the fundamental privacy rights of Californians and the impact on business and innovation. And it's very important that we listen to everyone who has a point of view that they would like us to hear and that we need to hear. So I'm not going to pick up on Paul's opinions about any one party, but what I'm going to say is twofold. One is that, and this goes a little bit actually to what Margot was saying, what Margot was describing in the EU, sort of the various layers and various actors who do different parts of the AI Act and its implementation. And one of the great, I think, benefits of having a regulatory agency like we do in California is that we can serve as that middle layer. So we have the statutory language, which I more or less quoted to you. It's very general and broad. And then our job is to implement it. And our job is to, so we are sort of a middle layer. And our job is to implement that through a formalized process that provides formalized opportunities for input from all interested parties. And we have had a lot of participation in this proceeding. We've had participation from some of the trade groups, the industry groups, some individual businesses, civil society groups, consumer groups, labor, and workers, just to name a few. It's been very valuable. And what I will say is what I think it's fine for me to express this. It's just Jennifer, but I say it over and over and over again, is one thing that is incredibly important for that process to be fruitful for everyone involved is that that the participants participate with specificity and with reference to their own expertise and knowledge. It doesn't help me if you are giving me essentially rhetoric. I mean, it is helpful for me to understand the values. But in the middle layer, what is helpful for me is if you explain your problem or your benefit with specificity, preferably with examples, and I do understand that companies, for example, have confidential information, but with specificity, and give me an opinion with some specific direction about what to do. Sorry, I'm tapping the table. That
You really mean it.
I really mean it. That is what is helpful. There's an additional challenge, which I think is incumbent on the agency, it's incumbent on all agencies, it's incumbent on us as a people, that we get as many perspectives as we can. And this goes to what Deirdre mentioned in her talk, finding ways to reach a broad range of stakeholders, not necessarily just the usual players. But I think there's a tremendous opportunity here, and the processes provide for, have the capacity to go far beyond those tropes and that type to try to solve the problem. But it is a job for everyone involved.
Can I add a little gloss on that?
Sure.
Because it's one of the things that interested me most at Colorado, and I'm only going to speak from my own impressions. I don't want to say what anyone else on the team thought. We would compare notes. We would go to the Colorado open meetings, and we were astounded by how much participation you had that you were just describing. So there's this one feeling out there that a problem with a 50-state approach is industry can afford to carpet all of it, and civil society can't afford to hardly participate in California. That wasn't my experience in Colorado at all. In Colorado, we would get a tiny, participation from industry. And so maybe we're suffering from the lack of kind of input that Jennifer's describing. And meanwhile, you would have someone from civil society who was just much more sophisticated, much more informed. Sure, they didn't know the Colorado law as well as they knew California. And so in a funny way, like industry, for whatever reason, would send their B team. There were only 2 states in the country that did a rulemaking over their privacy laws, California and Colorado. You would think that we would have merited more pushback and participation than we got. I don't know if this is generalizable. Maybe there's just something about Colorado. But I'm here to like burst bubbles about what happens necessarily when you do things like this. And this is all open record. Look at the testimonies we were getting. We weren't getting every company on earth. We were getting like 1 or 2 lackluster Denver-based trade association representatives and really, really, really smart civil society people. And so it's just a phenomenon that I find fascinating and very different than what you have in California.
Thank you. I think the issues that we're addressing are of great concern to many people, and definitely we've been talking a lot about collaboration and mutual respect. And I would just emphasize that these issues have to be addressed through collaboration and being respectful of the various viewpoints of the different stakeholder groups. I have a question targeted at you, Jonathan, but I believe my other esteemed panelists might have additional insights. Within the state of California, through the executive order, there was guidance developed around procurement. And procurement was or is really one of the strongest mechanisms for holding third-party vendors accountable. How has that been operationalizing in practice? Are you seeing pushback by vendors on sharing any confidential information, issues around transparency and accountability of the models? And then the second part, which I would love to hear from Jennifer and Paul on, is, as we are navigating this space, we're seeing this, burgeoning cottage industry of third-party auditors, verifiers, licensors of these tools. How do we ensure that those third parties are doing a robust enough job for us to say, yes, this was audited by a third party, we trust that process, or we don't?
Yeah, that's a great question. And as I mentioned before, we just recently released the actual procurement policy itself, which that, along with all of the work that we've done under the executive order we've put online, we have a website, genai.ca.gov, so definitely recommend you check that out. That has everything from that initial reporting on the risks and benefits to the guidelines to policies to information about the proofs of concept. And I'll be really honest about, I think the procurement work that we've been doing is really important and has gone really well. I think kind of the other side to what you were talking about, Paul, and what Brandie's alluding to is when you have kind of bigger states like California and Colorado, when you're able to set these kind of regular standards around procurement or consumer privacy, those just kind of get baked into state government procurement in general, because even though you're right, these companies are massive, they're huge, it is kind of inefficient to have like different rules for Washington state than the state of California than Oregon. And there is some differentiation there, but we're able to kind of also kind of bring people into those areas where there are commonalities in values and what the state is looking for. And so we found that it has been really helpful to engage in those conversations with vendors, asking for more information on AI. So trying to understand, how is your model trained? How are you trying to prevent and mitigate bias? What does it look like for your model to be successful? How are you updating it? And there are kind of 2 situations that we ran into. One is we've run into vendors that are a lot more sophisticated, and then we've really been able to dive into the details and understand a lot more about how does the technology that they're selling actually work? Because in some cases, we're learning that some things that are being sold as Gen AI are maybe not really as generative as they're saying they are. And some things maybe that we wouldn't expect have a really complex technical component. On the other side, when we are working, and as with a lot of state folks here, we work through resellers in a lot of cases. We're not doing as much business directly through procurement with some of the big tech companies. We found that that was really helpful because we were able to get those resellers for the first time to really dig in and understand what is our policy if there is a data breach, or what are the protections that we have in place? And if there's a concern around maybe that's not sufficient, we've been able to work with them and that vendor to make those improvements. I think the area where we've made a pretty significant change and a pretty significant improvement is, like we were discussing before, when we had started these guidelines, we had assumed that most of the Gen AI that we would be seeing would be like custom developed, highly like mission specialized solutions. And in reality, because of the way that we do our procurement and AI governance, where we're asking all of our vendors to actually disclose if they're using Gen AI or not, because we don't always know when we're purchasing something if there's a Gen AI component, we're finding that a lot of vendors were saying, yes, we are using Gen AI. And it was not a good fit for this very technically intense governance process, because there were literally vendors who supplied office supplies or who did landscaping who were using Gen AI for meeting notes or to write emails for marketing or something like that, we were then having these very detailed technical conversations about the models they were using to write their marketing emails. And that was just not a good use of everybody's time. So one thing that I think is a really great path forward for us is we've really streamed down and streamlined some of those paperwork requirements for vendors, especially those that are not engaging in a technology contract with the state. And so, like we're talking about, I just encourage folks to be adaptable and keep getting that feedback, like you're talking about, Brandie. Like, it's really important to get that feedback from all different types of people, because we're getting good feedback from our residents, from the community about what are they concerned about. And we can also get feedback from vendors around, do I really need to answer all of these questions around, how we're using MailChimp or Canva or something like that? That's a more general tool. So it's been really helpful to keep that dialogue going and then build in that deliberation into our own policy process as well. So as we move from guidelines to this actual policy, we can make that policy a lot easier, not only on our vendor community, but on our own staff as well. So we can focus on those higher risk items and not be reviewing every single contract, since Gen AI is pretty much everywhere now.
I don't have a lot to add to that, but I will go back to the theme of being sort of the middle layer as the regulator, whereas Jonathan is describing being the procuring actor, and having a role that I think of necessity, or perhaps this is my opinion only, appropriately would be at a sort of more detailed level, and also being able to adjust as things on the ground become more apparent, as you described. I would certainly refer folks to the draft cybersecurity audit regulations, which, for example, don't specify an auditor or auditors specifically, but say that they need to be sufficiently independent and have guidance as to how independence would be determined, and have guidance and proposed regulations about what those audits need to, what an audit would need to undertake and what it needs to produce. It's kind of, again, it's sort of that middle layer. And it's that brings me to an additional point about the middle layer, which is that regulations can be changed. It is certainly a rigorous process, particularly in California. There's formal rulemaking, and it's a lengthy process appropriately in order to receive the input that I mentioned earlier, but it is something that is intended to happen as facts on the ground become known or change, and it's different from the legislature's role, which is simply, it's just a much bigger lift to change the relevant statutes. So the middle layer, again, I think is really relevant here, and then the actors on the ground who are doing the procurement, very relevant.
And then on third-party auditing, I think we've seen more ways that can be toothless than effective. So I'm with you. Like, there's a real incentives problem. There's a real resources problem. I mean, I'm one of these people who is watching keenly the kind of FDA for algorithms discussion that's been going on, where the government itself, with kind of serious resources, of course it's a weird thing to be saying right now, does post-market surveillance of its own, right? And you can imagine kind of expanding that a bit for red teaming and kind of setting up places where people can come assist the government instead of having companies involved at all in selecting their auditor. I also think there's like an opportunity to kind of harness and focus the academic research community a bit more I go to so many places where there's so many brilliant PhD students and postdocs, and they're doing research like tinkering around the edges of what they can see with Wireshark that this company may or may not be doing. And I will often pull them aside and say, what if we just gave you a subpoena instead? And it breaks their brains. They're like, what do you mean? I thought this was just a black box and we wouldn't be allowed to peer in it. This is not going to scale really well, but it can scale a little bit better than wasting all of that talent on the kind of second and third order questions they've been looking at, right? If they could instead use that brilliance to interrogate the weakest or most suspect or most critical parts of the system, we might actually learn a lot more, probably spending less money along the way. So.
Great. Thank you for that, Paul. And I'll just call everybody's attention to the fact that within the state of California and at the federal level, we had a bill called the Platform Accountability and Transparency Act, PATA. It died, unfortunately, but it would have created a mechanism where the NSF would essentially verify, validate that a research question was of great merit for public interest and essentially compel companies to give over data so that they could investigate, of course, with some provisions around the proprietary nature and making sure that there was no personally identifiable information in that data. However, the European Union did pass a law, the Digital Services Act, that does this exact mechanism. So we're seeing the European Union being able to do that. Also at the federal level, Senator Hickenlooper, another Colorado, a Democrat from Colorado, introduced the Validation and Evaluation for Trustworthy AI Act, which would have charged NIST with developing guidance on what does an appropriate third-party certification, license, audit actually look like. I'm hopeful that legislation like that will be reintroduced again. And with that, I have one last question for all three panelists, and then I want to open it up for questions from the audience. Again, please remember to grab that mic before you ask your question so that we can capture it on the video. My final question for you all is, really, what is the single biggest risk and the single biggest opportunity for state governments in approaching responsible AI governance?
So I can get started. I don't know if I can actually answer that question or not, but I'll give you a couple of things to think about. So in terms of the biggest risk, I think the risk really is creating a false sense of security and doneness. I think one of the things that I dislike the most that we have a tendency to do in government is create checklists and some of these very specific procedures for things that are inherently done better with that collaboration and deliberation. I think a lot of times and this is not, I'm not calling out California specifically or any other state, but it's just a tendency in government to say, we're gonna do a equity review or a race and social justice review before we procure a product or set up a project. And a lot of times that's the end of the conversation, or we've certainly, if you're a government technologist, have unfortunately been in places where you build something and then after you try to figure out how can we make this more accessible instead of building accessibility into that design. And so I'm glad at the state of California, these are things that are priorities for us that we're trying to build into the guidelines, the policies, the things that we're using. But I have seen a lot of, well, if my state workers take this one 15-minute training, then everyone knows everything there is to know about Gen AI. If we check every box on this checklist, then we know that this product or project will lead to an equitable outcome. And the bottom line is we can't know that. And so rather than trying to force certainty into these kind of unknown situations, I hope we can embrace more deliberation and engagement with those stakeholders so it's more of a process than just a definitive yes or no. And I think on the flip side of that, the real benefit is the state can really impose its values on these technologies. That's the one thing that I think about a lot, and a lot of times when I'm speaking with tech or industry, they ask me about well, what's the one thing you want us to take away? And the one thing is to have that flexibility for us to be able to utilize these systems with things that we care about. A lot of the AI tools that are built out there are built for productivity or efficiency, And that can be really complicated in a policy context. It's a lot simpler if your strategic objective is just to maximize profit or revenue or shareholder value or whatever that is. But if, for example, we have a proof of concept around managing traffic in the state. So we're looking at how can Gen AI help us better manage the lovely traffic that many of you experience as you're driving back and forth from San Francisco and in Southern California. And one important question that we had to ask throughout that process is like, who are we optimizing this traffic for? Are we considering people who are pedestrians or people who are cyclists? Are we considering people who maybe don't have the resources to be able to get a bunch of private transportation? Are we thinking about how this affects public transportation? And thankfully, the answer was yes. It was really cool to see how those teams were able to use their expertise and use the community to build those considerations into those models. But out of the box, a lot of what we're seeing as these kind of like general productivity tools, a lot of these big advancements in technology, which are admittedly really fascinating and give us a lot of new opportunities, are not, are coming with that blank slate and are coming with a particular eye towards business. So hopefully folks will use this opportunity, as we're talking about, to make that voice heard and make sure that the states who are procuring and using this technology are thinking about it in the context of those broader values that you all care about.
Great, and then I'll just kind of summarize for each of you what I'm hearing. And so I've written essentially respecting the need for multi-stakeholder engagement and humility in the process that we're all still learning. Would you like to go, Jennifer?
Sure. I think the seeds of opportunity are found in the risk. And my what I want to say about this is really probably a little bit more academic, but it ties, I think, to how we actually accomplish policy. I think a lot in thinking about the work that we're doing at the agency. I think a lot about the Colin Ridge dilemma, which I'm sure many people in the room are familiar with, but some people may not be. And if you're not, the dilemma is that when you try to regulate something very new, technology is the core of the Colin Ridge dilemma. Inherently, you don't have enough information to do it necessarily well, or certainly not perfectly, but by the time you have enough information, the harms could be profound and irreversible. I'm not stating it exactly the way Professor Colin Ridge stated it, but that's sort of, in my view, that's how I see sort of the core of the dilemma. And when I mean that the risk contains the seeds of the opportunity, is that there's an obvious risk here, right? Which is that you get it wrong. You're on the wrong part of the timeline. You overstep, you understep, and the fear of that is that there's kind of no way to get it right. That said, we have a lot of information, again, about sort of where, or we can have a lot of information about values, about where we need to go, and about and some tools that we have to get there. And as long as we're flexible, to Jonathan's point, we're not just one and done, and we're willing to revisit, it has the seeds of opportunity. The opportunity, as we've been talking about throughout the course of the conference, of course, is to promote human flourishing, to protect human rights, and to build innovation. And I want to say a little word about that because the Colin Ridge, specifically the Colin Ridge dilemma, often comes up with sort of a view that like you throw up your hands and you can't regulate because you're just going to mess everything up. And here I think I can go ahead and voice this opinion because it goes all the way back to when the CCPA was being conceived by Alistair McTaggart and some other people, which is that if you have an appropriate framework and and you can amend it if you need to, you can create the conditions for innovation that is sustainable and that helps promote those values. They don't have to be in opposition as long as you are in a reasonable place on the Colin Ridge timeline and that you are thinking about that as the ultimate goal. That was one of the main goals behind the CCPA, to create a playing field where instead of a race to the bottom, where no company could offer privacy solutions and make it in the marketplace, to a marketplace where there's sufficient regulatory certainty and sufficient guardrails that you can have companies begin to compete on privacy protective solutions then you can end up in a good place without reducing innovation, but indeed supporting innovation that is in a more positive direction than the sort of race to the bottom that those drafters thought that we had. So I think the opportunity is contained actually within that dilemma. We have opportunities, given the federal government situation, that are not opportunities that seem very positive. So that's where I'm going to stop.
No, I think that's really helpful. And I will show my background a little bit. I'm from rural Iowa. Grew up among many a corn farm and soybean farm. I love your point that seeds of opportunity are found in the risk. And I would add to that, it's important to ensure enough sunlight or public awareness, soil nutrients, an enabling environment, and a hedgerow. Who knows what a hedgerow is?
Oh, gosh.
Okay, good. Those would be our
Ozarks.
guardrails. Those would be our guardrails to enable a good yield.
I have no idea what you just said. I grew up in suburban Orange County, so I don't think we have hedgerows. So my opportunity, and I actually heard seeds of this in what all three of you have said, which is almost like the word regulation almost is the wrong word. Like what we're all talking about is bringing our values to the table, working together cooperatively in things like you're building in California, co-designing kind of the future. I loved what you said about, thinking about streets for bikes and pedestrians and not just cars. And it's sort of what we've, really been bad at for 50 years. And there's been this privacy by design and security by design kind of movement baked into a lot of the recent laws. But they're really still this kind of us versus them, right? The companies are the ones designing, and the best we can do is lob requests, over the hedgerow. And instead, I have no idea what that means. And instead, I would love to think of a vision where it is much more collaborative and participatory in a meaningful way. The risk, which maybe is a call to arms more than a risk, all of our other institutions are being attacked right now, and state governments maybe are alone in a track record of backbone and standing up to things like this, and B, it's a little bit harder to cut their legs out from underneath them. And I'm of course thinking of like the last week of what we've heard about the mass media and Jeff Bezos, and right, it feels like all the other institutions are either folding or under attack. And so it's not just a risk. I mean, this may be the only game in town right now, at least for the next 2 years, is to have governors and attorney generals and state legislatures stand up and fight back, and it may be our only hope at this point. Right?
Yeah, exactly. I think we are definitely going back to some more of our state strategies. So now we do want to open it up for questions from the audience, and as the mic is passed to somebody with their hand up, I just want to say I find it interesting that we're talking about significantly advanced technology, but we've given examples from like 18th century quilts, seeds, and more. But where is the mic? Is there a mic being passed around the room? Right there.
Thank you. Terry Oley with Economic Security California. This is a really fascinating discussion. I work on state policy, touching on AI. And one of the things that strikes me, and Jonathan, you probably have some thoughts about this, but others too, is that we are sorely lacking in sort of a rubric, an infrastructure, regulatory scheme in most states, certainly in California, that is kind of equipped to deal with all of the policy making that people would like to do and that's proposing. Last year there were 60 plus AI bills in the state of California. Some of them would have called on the government to, require information, accept information, regulate, et cetera. And we just didn't have the infrastructure. So every one of those bills kind of bumped up against like, oh, you were gonna have to set up a new agency. Oh, we're gonna have to set up a new department, which, is like that, building the plane while flying. It's like, and also the airfield, and also the runway, and also training a pilot. And so just curious about thoughts about how we invest. And, and I think this stems in part from tech being sort of under-regulated, if you will, for the last 40 odd years. Can you talk a little bit about how we set up that rubric and that infrastructure so that there's even capacity in state government to, evaluate, deal, and dodge and weave a little bit with some of these proposals that are coming forward?
So I think like Jennifer said, this is ultimately what's really tricky about this type of regulation, because You have to kind of see into the future, and you have to also give yourself enough flexibility. I would recommend, even though both of these have kind of been rescinded, I do think, and I don't know if Olivia is still here, but the federal government under the Biden administration did a great job of laying out some different frameworks that you can consider, both through NIST in terms of like an actual cybersecurity security framework, and the AI blueprint for a Bill of Rights was extremely influential in what we built out. I think there were a lot of good elements there that could help you ask those questions to ascertain what those values are. I think the part that's really tricky right now is industry has not coalesced around a solution. So you might remember the Biden administration brought in all of the big tech companies to talk about, here's what we want to do. And there were some general concepts that made sense, like watermarking, but we still don't really have like that one watermarking solution that everyone uses. I know, at least in my experience, after that had started being floating around, most of those companies have then come back to the state to be like, hey, do you want to invest in our unique watermarking solution, hoping to become the market leader in watermarking for Gen AI. So it's going to be tough because we need to work through academia, industry to understand like what are those solutions going to be. But I think in the meantime, there are frameworks out there that highlight, like high risk is a great example. Helping to define high risk early will put you ahead of the game when there finally is a specific solution. So you can start to incorporate those into kind of that higher level framework. So definitely recommend you check some of those things out. And hopefully you can find them on federal websites right now.
Thank you. Next question.
Thank you for the panel. It's been fantastic. I have two questions. The first is I'd love to ask the panelists to speak a bit to issues of federalism and preemption that they might be foreseeing down the line as this patchwork of state laws grow. Obviously, net choice, the big bad wolf, has kind of gotten that started, even though the preemption part of it became nothing. And is it going to be a problem, given that the last panel touched a bit on the potential lack of federal legislation here? So kind of, we've talked about where Congress might go. I'd love to hear the panel talk about what they think the judiciary might be doing. And then the second question is, Jonathan mentioned startups and student-led initiatives as key in developing the kinds of localized solutions the state needs, but how those exact initiatives can be hamstrung by a lack of resources compared to big tech. And that made me think of, the recent revelations of DeepSeek and how they use distillation. And so I'm wondering if the panel has any thoughts about whether the interests of state and local procurement kind of place a normative finger on the scale in favor of making terms of service against distillation unenforceable.
I can answer the second question. I defer to my panelists on the first one. But I think in general, we want to have a goal to make it easier for smaller businesses, startups, folks who don't have a ton of experience with the state to do business with the state. And I've been really pleased to see, we have it's called the Department of General Services at the state, but that's our department that leads procurement. They're in the same agency as us, as well as our HR department and our performance and innovation team, the Office of Data and Innovation. So I think, when we talk about that feedback, that's the kind of feedback that's really helpful for us. One thing that we've done, in addition to the policies that we've talked about, is we're putting a much more explicit emphasis on development. So other thing I dislike that tends to be a reality in government is because the way we do funding and budgeting and governance, it really incentivizes the state to hand over a big pot of money to a big vendor, because you only have so much time with the money you have. It can be really difficult, if not impossible, to get capital dollars, especially for something that may not be like explicitly put out there in law. And so I've been working with our colleagues at DGS, with our colleagues within that government operations agency, and we're actually building in concepts like a proof of concept, a minimal viable product into our procurement process for these more like emerging technologies or these more kind of like innovative problems where we're looking for a really unique solution. So we're hoping as part of that, we'll be able to open up the playing field to a lot more folks. And one thing that I was really pleasantly surprised about is when we did those proofs of concept, we utilized a new procurement tool that was developed by Governor Newsom called a request for innovative ideas. So it's essentially a challenge-based procurement that has those development concepts, a proof of concept, an MVP. It allows for us to look at multiple vendors as part of the regular procurement process. And I would say, and it's public who we've been working with on these proofs of concept. You can find that on the website. But in addition to some of the usual suspects that you might expect, we did have a bunch of startups, or at least smaller businesses, be able to participate because we were primarily looking at what are the concepts they have, what were their solutions to problems like solving traffic or improving inspection of healthcare facilities, things like that. And so the more the state can embrace that and again add that flexibility in there instead of being so prescriptive, I think it will give more opportunities because we'll be evaluating things more along the lines of what is the innovative solution that a student or a startup might be able to come up with, and be less hamstrung by, if you have a more intricate knowledge of our contracting rules, you have a leg up on all of these folks who may not understand all of the requirements.
I mean, preemption is not my area of expertise, but preemption is not the thing I'm worried most about, right? I mean, Congress, I don't think there's a current law that clearly preempts the AI efforts. I don't think this Supreme Court's going to be eager to invent some sort of implied preemption. I worry a lot more about the First Amendment weaponization. I worry a lot about, not a lot, I worry a little bit about the Dormant Commerce Clause, although I'm not sure that's going to have legs. I'm not that worried about Section 230 in the context of these laws. So yeah, I mean, there's a whole host of things used to attack it. Preemption's probably not high on my list of concerns.
Preemption's not low on the list of my concerns. And that's based on history. Now, it isn't AI specifically. Congress got down a path a couple of times on a comprehensive consumer privacy law in the last couple of Congresses. I applaud the effort. And I think California at the time has been very aligned on this. So the governor's office, the attorney general's office, the state legislature, both the Speaker of the Assembly and the pro tem of the Senate, and the California congressional delegations fully aligned. California wants everyone to have privacy. We don't want just Californians to have good privacy. However, these bills had extremely broad preemption provisions in them. And while they did some carve-outs, which I really do appreciate for example, for the CPPA to enforce certain things, this is not about, this is not about a parochial protection of the CPPA. This is about the fact that California has a constitutional right to privacy, Article 1, Section 1 of the California Constitution, and our implementing law has a floor of protection. It cannot be amended unless it's in furtherance of the purposes of the statute without some very strict procedural requirements that I won't go into. That is a floor intended to prevent, as I understand it, when the drafters were working on it, that spiral to the bottom because you amend the law and the floor falls out. If that, I cannot, and the board unanimously agreed at least 2 times, we took official positions on bills, we cannot do anything but oppose a preemption that would remove that floor. And there are lots of, for Californians, our duty is to Californians directly. There are lots of other options. HIPAA allows states to build on top of it. If they have stronger protections, they can build on top of it. That is typical for laws like this at the federal government, and it's just not necessary to preempt all the state laws for the reasons we talked about earlier, that the patchwork is not as scary, in my view, as sometimes it's presented to be.
Thank you very much for that. We have time for one more question. If we could get into a different section to give some of these folks a chance.
This is a question for Paul on how scary or not scary the patchwork is. So in the privacy space, yes, there's a patchwork, but then you also said the patchwork may not be that kind of diverse because of harmonization and compatibility being built in, or even third parties that act as intermediaries. So if you fast forward for a few years, how do you think will the patchwork of AI, regulations maybe? So is it going to be the same, or, I mean, one reason that the patchwork may look much more scarier is that the stakes may be much higher, in particular when the states are actually the only regulators in town.
Yeah, I mean, for one thing, we've just begun. Like, no one knows how to regulate AI at this point. There isn't a huge diversity of options, and so that's one reason you're right. For now, you're not going to see a lot of divergence. Maybe some states will get really creative. I mean, if you want a frozen moment in time, so Virginia just passed a law a few days ago. The governor has a month to sign it, and if you read the commentary, people will say, this is the business-friendly version of the Colorado law. It couldn't be more different, right? This is night and day. And on one level, they're right, like the burden on industry is a little bit different. But when you read the statute side by side, they're almost word for word, right? They've changed a few words that have a lot of import. I'm not denying that they do. So right now, we're not headed for even a patchwork. We're headed for a lot of harmony. Yeah, but you're right. Like, someone might come up with, I mean, AI is just at such an early age of regulation that there will be change in diversity. I also, though, think states will talk. One thing we haven't talked a lot about up here is there's a healthy competition. Like, every state wants to do what the last state did, but do it a little bit better and a little bit more protective of their citizens. And so I think that tends to lead to harmonization. That tends to lead to, like, following what the last person did, but doing it a little bit differently. So that's still my bet, but you're right. Who knows?
Jennifer, Jonathan, anything to add? We only have a couple minutes left if you had. No, nothing? All right, we have 2 minutes left, so if you have the shortest question in the world.
I think Pam's been waiting.
Oh, Pam here.
So one thing that strikes me about the auditing as a tool is that we're in such an early stage of the technology development, and one of the things that makes auditing work at a national level is that there are generally accepted guidelines, and I don't see that happening anytime soon. So I think it would be useful to try to figure out what kind of process could lead to the development of at least some minimum standards for what an audit really ought to be about, and how to then try to essentially create a kind of community around that. That actually strikes me as one of the things that states could do. Probably they have more interest in that immediately, but I'd like to get a little comment on that, because that's one of the things that's been worrying me. Audit, oh yeah, that's great, but it's like, if you don't have any standards, you're in trouble.
Yeah, I'll say I couldn't agree with you more, and I think that we should have our own version of an AI Act in California, where we set some of these standards, but also there's standard setting bodies like IEEE, ISO, and Nonnecke, and there are coordination efforts across them. Now there's this issue around the proprietary nature of standards, that you have to pay for them. Industry is a big player in standard setting bodies as well. So I totally agree with you that this is a great concern to me as well.
I agree. I've been interested in Jonathan's thoughts, because it sounds like you've been struggling, or not struggling, right? You've been addressing this issue, essentially the results of what Pam is describing as it comes up, and you look at the system, it's not doing what you want. Is there a way to reverse engineer that into some standards for what an audit should do?
Yeah, I think the short answer, because we only have like a minute, is for these types of technologies and these types of efforts, you're going to get out what you put into it. So it's been disappointing to see that a lot of the marketing has been, we can remove all bias from your models. We can make sure it's 100% accurate. I think that's very unlikely. And to the theme of today,
advertising.
yeah, it's borderline. Yeah, there are lawyers here, so maybe that might be legally actionable. I don't know.
Yeah, that's the easy problem. That's all right. Yeah.
So kind of building off the theme, I think to your point, let's utilize some of the tools we have in terms of those pre-established technical communities, but also as part of the rulemaking process and other opportunities for deliberation and feedback.
Nope. Good?
We've been told to
We're
stop.
done? We're stopped? Okay, well, please join me in thanking the esteemed panelists today. Thank you so much.
Great.